Folks, this is Mike Newmeyer, and I'm your friendly financial advisor here in Owings Mills, Maryland. And I've been doing this for over 25 years, and I've been helping a lot of people get ready to retire. So, I want to talk to you today about estate planning. But before I get to that topic, I want to tell you about some of our programs that we have. We have one program right here that pays you out. If you're 65 years old, you can get 7.5% for life. So on 100,000, you're talking about $7,500 forever for your life and your spouse's life. $7,500. Last week, I got a call from a fellow that says, I heard your radio show. He said, what I want to know is, how long does the money last? And I said, it lasts for your life. He says, yeah, but how many years? I said, I don't know how long you're going to live. Start it now. Start it now and get it for the rest of your life and for your spouse's life. So if you pass, she gets it or he gets it. So that's the way that works. So that is what's going on right this minute, okay? And we have lots of other programs that are available to you. And you can get this for any years, any age, anything over 60. Okay, anything over 60, you can get lifetime income, and it's always different based on the age, okay? So call me, 410-902-0464. You can look at our website, Game Plan for Retirement. You can learn more about us there. You can listen to old shows by going on there. You can look at other topics and so forth. And our numbers there are contact information. We're in Owings Mills. You can call me. I'll talk to you about anything you want to talk about. You can make an appointment if you like. There's no obligation. And there's no obligation in the appointments, okay? You don't pay me for coming in for my time. I make my time available. I like to help people. I've been doing it for a very long time. I've got lots of experience, and I'm more than happy to give you advice, okay? So that's that. That's who I am. That's what it's all about. Now, we're going to talk about estate planning today. I want to tell you something that you probably never heard before, and that is that you ought to start working on estate planning in your 50s. I mean, if your longevity tells you you're going to live to 85, that's irrelevant. The reason I say you should start it in your 50s, in fact, you should start it while you're still working. Why is that? Because then it will give you a picture of your financial strength. It'll give you a picture of where you stand economically so that you're able to make plans. Then you'll be amazed at how many people discover things if they do it early enough. And they can make changes. They can see that they need to accumulate more money. They can see where they're going to use their money in retirement and after they're gone. They can make all kinds of decisions, and the husband and wife will find that they're learning things about each other and about what each other wants to do, and wants to do in retirement if you do the estate planning early. A lot of discovery, a lot of information you never thought about will surface. And you'll do some estate planning then, and you'll make changes later. And that's fine. That's fine, making changes later. In fact, if you do a will or a trust, you can always change those things. And you ought to review them anyway, about every 3 years, from what the attorneys tell me. Now, let me tell you this. I am not an attorney. I've been doing these seminars for many years. I can give you the basics, and I'm not an accountant. So I can give you the basics about that as I talk about taxes too, and I give you basics, but I'm not an attorney and I'm not an accountant. And I don't make any claims along those lines. So you need to always go to the professionals for it. But I hope that I give you the directions on where you ought to go and the things you ought to be concerned about. Okay. So estate planning. First of all, and this is all from my seminar, and incidentally, we're going to repeat this seminar. When all the topics are covered, we're going to start over. So you'll be able to pick this up off the website, but we'll also be going through it again. And that's the idea, is to take you through all the topics and then repeat. And then we'll insert some new information along the way. Okay, so what about the documents and your intentions? You start out with some very basic ideas. You write down with your spouse or if you're by yourself, the things that you want to accomplish in estate planning. What do you want to do? You want to decide who's going to be your beneficiaries. On many things, you've got transfer on death. Those things don't need to even go into a trust because there are transfer on death through operation of law, which is the term they use. Those things pass immediately. to the other person. So you don't have to worry about that. And things that are jointly held, like savings accounts and that sort of thing, immediately become owned by the person that's sharing it with you in that account. So there's many things that will not go into the orphans court. The orphans court is basically, where our wills are processed in the state of Maryland, the orphans court. So that's something if you can avoid the orphans court as much as possible, that's great, because you get your work done faster, and your assets will be bequeathed and passed to your beneficiaries a lot faster than they would if it went through the orphans court. Okay, so you think about what you want to do. You want to think about who you want to transfer assets to, and so forth, or the trust that you might want to choose. You have to learn about trust. Attorneys can go through. What's a testamentary trust? Well, that's a trust that's established after you pass. Testamentary trust has special purposes, but it doesn't even come into existence until after you're gone, okay? And you have to think about things like guardians for your children. That's another reason why you want to do it early. You want to think those kinds of thoughts through and make decisions and talk to your family members and so forth and so on, and think about a horrible fact that can happen, which is passing early. You could be in an accident or something. So who's going to take care of your kids? Those things need to be worked out in advance, and they should be documented, of course. And then how about a person that makes medical decisions for you if you're incapacitated? Let's say you're single and you don't have a spouse that can do that for you. Basically, who's going to take care of you? Who's going to act for you to make medical decisions? And then how about appointing somebody to make financial decisions? So these kinds of things, are documented and are used. We use certain kinds of legal techniques and sanctions, in order to accomplish those things. Okay, folks, let's continue now. So after you're gone, you have to have appointed a guardian to take care of your children, if that applies. You have to distribute your assets and so forth, and who's going to get them. You have to minimize potential expenses. Okay, and incidentally, along those lines, be careful about people that want to sell you a final expense insurance. Most of the time, it's very expensive. It doesn't really do the job it needs to be done. And most of the time, you can cover those things with your regular life insurance policies. So be cautious of that. There's people knock on your door and they want to sell you final expense insurance, and it can be a ripoff. Okay, not always, but many times. Okay, you want to avoid legal and financial complications for your family. And this means you've done enough work in advance so that you can avoid those complications. You want to avoid delays in publicity. I don't know how many people would get publicity, but you certainly want to eliminate delays. And you want to transfer business assets according to a succession plan. So that's kind of a second kind of plan that you need to do if you have a small business or any kind of business. You need to have a succession plan. Some do, some don't. Some don't want to deal with that. They're in denial. They think they're going to live forever. I don't know. But you need a succession plan. All right. You got a plan for incapacity, okay? And, unable to make decisions for yourself. You've been in an accident or whatever, okay? Or an illness. So there we start. I'm going to give you some of the answers to these topics that I've now brought up. First, a durable power of attorney. Now, what is a durable power of attorney? Basically, it's probably the only kind of power of attorney you're going to need. A durable power of attorney, number one, does not end unless you end it. Okay, you always have control if you've got a durable power of attorney that you've issued. Okay, that's the first thing. It doesn't end until you make it end. But the second thing is you can be used for many things, like, for instance, doing bank transactions, and essentially you're putting the other person in a position so they can act in your behalf. Okay, in your behalf. So that's what a durable power of attorney is. There's other power of attorneys that are established for specific purposes, but this durable is the one that's powerful and can be used to do about everything. They're acting in your behalf as if they were you. Okay. A living will is a specific document that your wishes about being kept alive. So, this is do not no heroic measures, such as pull a plug under certain circumstances. Don't let me live in a vegetative state. Okay. So those are basically very important things you make a decision on. Your family doesn't want to make those decisions. Believe me, they don't want to say pull a plug. They want you to have made the decision in advance. Okay. Lastly, in this category, you want to leave a document that indicates whether you want to have your body parts donated, your heart, your lungs, and so forth and so on, to help people that are alive, that help them keep them alive. So this is where kidneys come from, and in many cases, and so forth. So you make a decision about that, and there's a special form that you fill out. Okay, so those are important. And then taxes, minimizing your taxes. Now you work with your accountant, and you work with your estate attorney to insert into your documents the necessary tax kinds of documents that deal with all the ramifications of not preparing for taxes. You are now prepared for taxes. Okay. Things like income taxes and capital gains taxes and so forth and so on. You can't avoid them, but you can minimize them if you take the right measures. And again, I'm not an accountant and I'm not an attorney, but keep those topics in mind. You need to prepare for those kinds of things. Okay. Gift taxes is an example. There's limitations on gift taxes. Yes, there are. But there's also things like in some states and so forth, they allow you, and the federal government allows you a certain amount that you can give away every year without any tax consequences and without having to file a gift tax return. Your accountant can explain that all to you. So you could be gifting while you're alive various amounts of money to family members and so forth and so on, or your church or whatever, and not have to file a gift tax return. Leaving it all till the end may not be in your best interest, may not be in the beneficiary's best interest. You can explore these things, with the accountant and also with the attorney. Maybe you can't afford to do that too. So those are all kinds of things you have to consider. And then the estate tax, federal estate taxes, and also estate taxes apply. Those rates change, and those things can be disclosed to you very easily by your attorney with the realization that they could change before you're gone, right? So you have to think about those things. And so there's generation skipping transfer taxes, a special category. Generation skipping transfer taxes. Now that's something that an estate attorney with the accountant will absolutely consider. The estate attorney, of course, knows about those kinds of things, but to a greater extent, the accountant does. So he's going to bring that up if it applies. All right. And then exclusion amounts. When it comes to taxable estates, there's definitely in other words, the first X number of dollars will be excluded from estate taxes. And that will change sometimes. Over time, it will definitely change for the federal and for the state. So, that's something that the accountant is going to help you with and help and work with your estate attorney. All right. Okay. And then, of course, we've covered the estate tax. Okay. And then your taxable estate. If you came to the course, I could go through great details on generally how to calculate your taxable estate. All right, we're not going to do that on the show. We don't have time. We only have a half an hour each week. But this information is here. If you come and see me, of course, I'm more than happy to give you more information. Dying without a will, that's not a great idea. That's called dying intestate. And if you die without a will, Maryland has a will for you, we always say, right? And so you're dying intestate. In this case, once certain assets are transferred directly, a probate judge will distribute your remaining assets. So what's transferred automatically? The ones that transfer on death or a beneficiary. Those things through operational law are transferred. But everything else is going to go through probate. It's going to go through the orphans court, which is what we have in Maryland, the orphans court, where where everything is probated. Everything is probated. I remember asking one of my kids back when they were teenagers, what is probate? What goes through probate? And my son said, one of my sons said, everything that is probatable will go through probate. I thought, well, that's a rather astute observation. Anyway, disadvantages of dying. A person or entity will be appointed to administer your estate. Yes, that is true. And you're not picking them. A guardian will be appointed for any minor children. And so a certain amount of money will be given to the spouse. A certain amount of money will be given to your children. But these things are not under your control because you died without a will. All right. You lose control over the expenses and time frame of estate distribution. The probate court doesn't have to get everything done in a month. Okay, I don't even know now if they have a legal limit on the time that they have to, process all this. But it's more up to them than anybody else. Okay, and sometimes a will isn't enough. The will covers a lot of things, and you want to be cautious that you don't do unnecessary things. If you don't need a trust, don't use a trust, because that's another expense that's involved in the estate planning. But it may not be a will, and so you want to find out whether you need more than a will. You can put things in trust in a where you can change things. As long as you're alive, you can change things in a trust. Okay, you can make different considerations available and so forth in a trust. So, but things are in a trust mean that they will have to operate that way when you're gone. They can't really be altered. You can be challenged in court, but essentially they're not going to be altered. And so be careful and be aware of that. Now, a trust doesn't go through probate. A will goes through probate. But a trust doesn't. A trust is a sacrosanct arrangement where they basically are going to follow your instructions, and they're going to divide up whatever you put in the trust according to your will, okay, your desire. So there are disadvantages to just having a will. For instance, your will is subject to probate and associated costs. Your will can be challenged again by creditors and so forth, can be taken to court. All information about your assets will become available to the public, okay, in a will. Your assets will not be available to your heirs until your estate is approved by the probate court, again, the orphans court in Maryland. And how often do you want to revisit a will? Probably once in 3 years, maybe less than that, depending on the circumstances and how many moving parts are involved, how many people in your family are involved, and so forth and so on. But generally, about once every 3 years. And I want to insert this at this point. My advice to people is always to use an attorney. Now, I know you can go online and you can download and you can buy a will for, you can probably get them at the stationery store. But I don't trust those. I've never trusted them. I'm not an attorney. I don't know all the things that are changing. I don't know all the ins and outs. I want an attorney to do the work, and I'll pay for it. And I may have to pay more later, when it's modified. But still, I'd rather have an attorney do it. And it's not typically that expensive unless it's very complicated. And the more complicated it is, the less reason you should be doing it yourself. Okay. So then what is probate? Okay. Probate is a state legal process. I'm going to read this one. To identify the value of what you own and distribute your assets following your death. If you do not have a will, assets subject to probate will be distributed according to state law. So you die intestate, then state law is going to decide how it's divided up, how much money goes to your wife and children and so forth and so on. If you have a will, probate will supervise the execution over your will's instructions. But wills do go through probate, so they are probated, okay? The advantages of a probate include providing consistent legal process for people who die without a will. So that's the advantage of probate. I mean, it absolutely means that they will go through a process, and it won't just, be distributed without that process, which keeps that process, gives it some integrity, and it makes it do what it's supposed to do. It'll determine the validity of your will and interpret its intention. If you wrote a will, handwritten will, it works, but the court needs to really interpret it because your language might be different and what may not conform to actual legal language. So it gives you that sort of thing. Provides a court supervision to ensure your executor is acting according to your will. That's good. A little oversight. Generally limits the time in which the will can be challenged and creditors can make claims on the estate. That's good. You don't want it coming back 5 years later. It pays debts and taxes and settles disputes and transfers legal title. So these are some of the processes that take place within the probate process in the probate court. It does not influence any assets transferred by other means. So transfer on death. If you have accounts, again, that are transfer on death or beneficiaries, those things, again, operate through what they call operational law, and that's done. So anything, that's all excluded from the will. That's all excluded. More things you can do like that, the more simpler it is, and so forth. So I always advise people, do as much as you can with transfer on death. The disadvantages of probate include probate-related fees and expenses usually average between 3 and 8% of the value of the estate. So that's a lot of money. So you want to keep that in mind too. That's another reason to transfer as much as you can, transfer on death, and so forth. Assets subject to probate are not available to beneficiaries or heirs during the probate period. Well, gee whiz. Let's say you leave, you're gone, and your spouse needs to use things, and they're in the will, but they're not in both of your names. Well, if they're in both of your names, then she'd have access to it. Well, what is she going to live on while she's waiting for probate? So those kinds of things have to be considered. All information about your assets will be available to the public. Not that they necessarily care about it, but they are available. So, you see printed material in the newspapers. Okay. How about gifting while you're alive in order to avoid probate and so forth? All right, so gifting while alive, opportunity to experience the recipient and seeing, your son or your daughter or whoever, receive these things and how it pleases them, and you understand what your bequeathing is done for them. So there's some psychological, emotional advantages, and reduces the size of your estate and your estate taxes. So taking advantage of gifting laws. How much do they allow us to give away each year? I brought this up earlier. Not a bad idea. If you can afford to do it, good idea to do it. All right. And then, you can give different amounts every year or skip years or whatever. You can do all those things. Disadvantages of making gifts include loss of potential price appreciation. So the time value of money. If I give something away now, that might have been worth a lot more later. Okay, so there's things to consider, and that's one of them. Loss of income from the gifted. So in other words, if I was taking money out of an investment to give it away, then I'm losing the interest it would have gained by staying there. So you have to consider all those things. To very wealthy people, it may mean nothing. It may mean a lot. To people that aren't as wealthy, obviously, the average person would have a different outlook on these things than somebody who has great wealth. Loss of control of how or when the gifted asset will be used. So, maybe we want more control. A lot of people want more control, but I have had people that their health is declining, and they want to do a lot of this gifting now because they're concerned about how they're going to, what kind of condition they're going to be in later, and whether they're really able to get things done the way they want to later on when they're less capable. So there's different reasons for different people. And then joint ownership. So if you think about joint tenancy with a right of survivorship, well, that means that basically that it is that other person's asset if you're gone, and that's transfer on death. While alive, tax and estate planning ability is limited. So other owners have access to the jointly owned assets. So there's a big time issue here. For instance, you might decide you're single and you have a home and you want your nephew to inherit it when you're gone. And you're not going to put your nephew on the title now. That's on the deed now. You're not going to do that. Why wouldn't you do it? Because he now owns it. He could in fact sell it. Not that he would, but he can. He can. So how do you make sure he gets it immediately upon your death? There is a thing called a life estate deed. A life estate deed allows the person to take over the complete ownership on the moment you pass. That's a good way, but he has no access to the ownership before you pass. So remember that one, life estate deed, big deal, absolutely, and it works. Okay, so that's very important. And then tenants by the entirety. In the state of Maryland, we have what's called tenants tenants by the entirety, and what that means is that if in fact you and your spouse were involved in some kind of litigation where the one spouse is responsible, that they cannot touch your home if you have joint tenants by the entirety. So a judge might award, folks, I want to talk a little bit about trusts, okay? Just to give you a feel for what they're all about. And then you can discuss this, of course, again, with your accountant, but primarily with your estate attorney. Okay, so what is a trust? I'm going to read some of this from my seminar because the actual words are important. The grantor, these are the definitions. The grantor, also known as a trustor or settler, that's the person that actually is responsible for the trust, the person that puts it together and offers it. That would be you if it's your asset. The trustee is one or more parties who hold title to the trust assets and administer the trust according to the specified terms and conditions. So you might have a son or a daughter or some family member that's actually the trustee. Their responsibility is basically to follow the instructions of the trust and distribute assets according to the trust whenever the trust says that you're supposed to do it, and while you're alive or after you've gone. The beneficiaries, of course, they're the people that actually get the assets from the trust. That's pretty obvious, I guess. And the trust agreement is the written legal document that is basically establishing the trust. So those are some definitions. Now, what are the benefits of the trust? I'm just going to give you some for obviously to kind of give you a framework. You can avoid probate. We've already talked about probate. Anything you can do to avoid probate means that you're doing something more efficiently, and it'll be finished faster. It'll be able to act faster, and you can isolate and transfer assets. Even if your will is going to be contested. Let's say you anticipate, your estate attorney says, this could be contested. This part of your will could be contested. Then you could put it into a trust, and where it won't be contested. You can distribute indivisible property among beneficiaries or equalize inheritances. You can do a lot of things like that the attorney can explain to you. You can protect assets from claims of creditors and lawsuits. Very important to establish those walls, around your assets to protect them and so forth, to make sure they go where you want them to go. Manage assets for a beneficiary who's unable to handle. So you have a special needs child, let us say hypothetically, and you want that child to benefit from certain assets, but you know that basically they can't take care of it. So you can put it in a trust and have a trustee be responsible to do that work. You can delay the transfer of ownership or possession of assets until a certain time. So in a trust, you can say, I don't want this asset distributed until such a time. Maybe it has to do with the age of the beneficiaries. There might be some reason like that, but you can decide at what time, what year, when you want it distributed. You can transfer the responsibility of managing assets or to plan for the possibility of incapacity. You can transfer that responsibility to the trust. The attorney will explain that further. And you can minimize or avoid income, gift, or estate taxes. And that's what the accountant can explain to you. So those are some of the beneficiaries of trust, benefits of the trust. Okay, now what are the different types of trust? And I've alluded to some of this in the past. Testamentary trust. So testamentary trusts are trusts that are designed, they actually come alive when you've passed. That's a testamentary trust. So that need for that. Of course, the attorney will explain that it makes sense in certain cases, doesn't make sense in other cases. A living trust, or referred to as an inter vivos trust, are set up and take effect while you're still living, and so those can be changed. Those can be changed. You can change the testamentary trust as long as you're alive, but obviously once you pass, then they're going to come alive, and they're obviously they can't be changed then. A living trust can always be changed as long as you're alive, and you have assets in them, and you can add assets to them, and you can take assets out of them. But they have the advantages we already described for trusts, as long as the assets there in them. Okay. Revocable trusts allow the grantor to revoke the trust or modify its terms. So you would make one of these. Living trust would necessarily be designed as a revocable trust, unless for some reason you didn't want it, unless you really wanted it to be irrevocable for some reason. And the attorney would explain to you whether that ought to be or not. Now, most people that have these kinds of trusts are revocable trusts because they want to have control. Now, if you had a person that anticipated their health declining and were concerned about people, concerned that these things could be a problem later, they might make them irrevocable so that they can't be touched in any way, shape, or form. Even the trustee couldn't change them. They're irrevocable. So that's another consideration. So revocable is typical, and you can make changes to the terms, etc. inside. You can avoid probate and publicity. You do not save income or estate taxes that are protected from the creditors. At death, trust assets must be distributed to the beneficiaries according to the trust. Trust tells the trustee exactly how to distribute the assets. It may reduce the risk of your will being contested because anything in a trust can't be contested. So if you don't want to worry about things being contested, then you put those items inside the trust. Let's see. Assets should be transferred and owned in the name of the trust, including transferring the title and obtaining a revised deed for real estate. That was something I just recently learned. So you want always to name the trust as the owner of these assets. It's always transferred to the trust, not transferred to the beneficiary. It's going in the trust. The trust will give it to the beneficiaries later. A pour-over will serves to transfer any assets outside your trust into your trust upon your death. So that's a very interesting concept because if you've died, any other assets that are existing outside the will or outside the trust can now be put into the trust, which of course expedites the transfer process. It doesn't have to go through probate, as we said before. That's what we call a pour-over will. Okay, so those are some things to understand. Charitable remainder trusts, I want to spend a minute on that, allow a person to get income from the assets while they're alive and then transfers the residue, what's left in those assets, to a charity. Could be a church, could be a temple, could be anything. Could be any charity that exists, you may want to leave it to. Okay, so that's what a charitable remainder trust is. They're widely used and available, and may not be applicable to your situation, and they may be. The attorney will advise you on that. And then irrevocable life insurance trusts. So here's a trust that's funded by life insurance, and they make it irrevocable. It could be revocable, but most of them are not. Most of them are irrevocable life insurance trusts, and a trust that has insurance in it. It could be simply for final expenses, or part of it could be for final expenses, and that is a pretty efficient way to deal with with final expenses, as opposed to buying the final expense insurance, which I mentioned before. I think in many cases is just a plain ripoff. So there's a lot more that goes into irrevocable life insurance trust, but it's something you can discuss with your accountant and with the attorney, and I'll be happy to talk to you about it also. And so those are very, very important. And then there's others like bypass, credit shelter trusts, and so forth. I'm not going to go into those today. There's a lot of detail in those. And others, like for instance, marital deduction trusts, qualified terminal interest trusts, that's Q-tips, and qualified domestic trusts. So those are some others. If you come in to me, I'll be happy to go through some of those to you, but that's about as much time as we have today. I hope you enjoyed the show. We've talked about a lot of issues for the estate planning process. Get started as early as possible. It gives you a chance to really measure your assets and where they're going to go and whether or not you're going to have enough money to stay retired and so forth and so on. And next week, we'll talk about, what are we talking about next week? I have to tell you right now. Basically, we're going to begin the process talking about life planning. So that's a general topic. That's the beginning of the seminar all over again. We didn't actually cover it this time we went through it. So we'll get back to that. Remember what we have to offer today. This is a great plan. 7.5% if you're over 65. At 65, it actually goes up from 7.5% the older you are. And so on $100,000, it's $7,500 a year for the rest of your life and for your spouses. That's a big deal. Call me, 410-902-0464. You can go to our website, Game Plan for Retirement. You can listen to other podcasts by going there and picking them off and so forth and so on. Give me a call. Let me try to help you. Thank you.